This is Kent Moreland. I'm the editor and publisher of morelaw.com, an internet-based legal newspaper. I'm here today talking to Tulsa employment lawyer Jeff Nix about employment at will. Many people don't really know their status as employees of companies, and we thought we'd talk about that a little bit today. So, what are the rights of an employee in Oklahoma generally to their job?
All right, well, as you said, employment at will is a kind of a generic term that covers the employment relationship in Oklahoma. And employment at will is simply this, that an individual can quit or be fired for any reason, good reason, bad reason, no reason at all, unless or except for their status. And their status is what you're born with. That's race, color, religion, sex, national origin, age, or disability. These are called protected statuses. The other type of protected status is action-based, and that is where the individual has taken some action that should be protected by law, and that is such as filing a workers' comp claim or engaging in whistleblowing. So if an individual believes that their status, that is race, color, religion, sex, national origin, age, or disability, was a factor in any aspect of the employment relationship, that would include hiring, that would include firing, that would include assignment, promotions, that would include wages, that would include any aspect of the employment relationship. If an individual feels like their status had played any role at all, and it doesn't have to be the motivating or it doesn't have to be the dominant role, it just has to be any role, then that individual clearly may have a claim for status-based violation of the employment relationship, and may have a wrongful termination case or a failure to hire case.
All right, well, let's assume that I'm short.
Mm-hmm.
If somebody decided they didn't like me in the job because I'm short, would that be a status-based termination, or would I not be protected by being short?
The protected statuses are race, color, religion, sex, national origin, age, or disability. Now, sex is easy, or what is the gender? Color and race are identical. Age is over 40, and there are some cases that say if, let's say, there are two people that are being considered for a job, and one of them is 55 and the other is 41. They're both over 40. However, there are cases that say if the employer is making a decision based on, still based on age, they want the younger worker rather than the older worker, even when both are over 40, they might have a claim.
Well, what if I'm white? Can I file a claim if I'm terminated because I'm white as opposed to terminated because I'm black or American Indian?
Absolutely. And ironically, the name for that, it's a misnomer, but that's called reverse discrimination. And it's only called reverse discrimination because most discrimination cases are where the person is non-white. But I have had a number of cases where the individual that's alleging discrimination is in fact white, and the people doing the discriminating are non-white. So the Civil Rights Act doesn't say, it's only for black or Asian or Hispanic, etc. It says it's for anybody who is being singled out because of their race.
Well, now it sounds like that might be kind of hard to prove, though. What do you have to make a case against an employer if you believe you've been fired because of your status, your race, sex, and so forth?
Well, that's a good question, and the answer is basically a lot of times you will only have circumstantial evidence. There will be a situation where women just are not doing as well in the workplace. They're not getting the good jobs, not getting the good salaries, etc. And you kind of imagine that as a line down here. And you imagine where they should be as a line up here. So women are not doing very well and men are doing very well, but it's not enough to establish this gap. You've got to establish a link. You've got to establish some element that you can demonstrate that connects these two lines. And that would be racial remarks, that would be gender bias remarks. Employers have gotten a lot more sophisticated. You'll notice I didn't say have been a lot more interested in equality in the workplace. They've just gotten more sophisticated in being careful not to provide these links, these lines, the race-based remarks, cartoons of a racial nature or of a gender bias nature. Employers are a lot more careful now about these so-called smoking gun linking remarks, but that doesn't mean that they're not still being done.
Well, what if you come up with some evidence like this? Does that mean you automatically win, or can the employer challenge the proof using, saying, no, we didn't fire them because they were African American or women. We fired them because they weren't doing well in the workplace. How is that handled?
Well, that's a good question. And the common thing is employers are obligated to establish a non-discriminatory business reason for making the decision that they made. And if they have a legitimate, non-discriminatory, and those are words right straight from the court's mouth, legitimate, non-discriminatory business reason, you start off with the idea, everybody's heard of burden of proof. The employee has the burden of showing that there's some indication that their status has played a part in the employment decision they're challenging. Now the burden shifts to the employer to come forward and say, no, here's our explanation. And so they have this legitimate non-discriminatory business reason. Okay, that swings the pendulum back to the employee to establish from these linking remarks that we're talking about, the smoking gun remarks, that they were discriminated against in this particular instance.
I've heard of the idea of pretext, or is it pretextual?
Pretext, yeah.
And non-pretextual reasons.
Right.
What does that? Those are kind of words of art, I guess. What does that really mean if somebody says they have a pretextual or non-pretextual reason for
right.
it?
Well, that is a variation of what I was talking about, legitimate, non-discriminatory business reason. They may have a real, every employer I've ever dealt with, and I've dealt with hundreds and hundreds and hundreds, I've never once had one say, oh, yeah, you got us, we did it, we just don't like black people. So they always have some explanation. I'd be disappointed if they didn't. But that really makes my job easier, because let's say you have a reason, these members of management sit around and they come up with, well, I want to get rid of this guy, but I just don't want to. The funny thing about employment at will, if you don't like somebody, you can go out there and fire them right then. Just say, you know what, I don't like you, you're fired. But they won't do that. Instead, they say, well, I don't like the guy, I want to fire him, but I'm going to come up with a really good reason. And everybody around them go, oh, that's just really great. Well, that's really, we're going to get them on attendance. Yeah, that's great. No, it's not. If they're not an attendance problem, what do you throw that in for? Employment at will? Tell them you don't want them to work there anymore. But no, they say, we're going to get them on attendance. Well, okay, now my job is to establish that attendance has nothing to do with it whatsoever, that it's a pretext. And the funny thing is, if you can destroy the pretextual reason, then there are cases that say, okay, Mr. Employer, you get one chance, and you bet your farm on attendance. And so you don't get to say, okay, it wasn't attendance, it was safety habits. Yeah, that's it. Now, you get one bite at the apple, and if you can destroy that pretextual reason, then you have really moved your burden of proof forward. You, the employee, has really been successful in moving your burden of proof forward.
Okay, now let's say that somebody comes in to you and they hire you.
That's my favorite part.
Well, do they have to pay you in advance, or these cases taken on a contingency fee basis?
No, my personal practice is on a contingency basis.
All right. Now let's say somebody, you agree to represent somebody and you go and you get by the motions for summary judgment and all of the challenges that the employer comes up with, and you actually try this case and you win it. What does an employee who's been wrongfully terminated because of race, sex, and that sort of thing, what do they get? What?
Well, you won't be surprised to find out I get that question.
Sure.
And on my website, TulsaEmploymentLawyer.com, I have a form, a damage computation form, and what an employee is entitled to from a point in time back to the time of the discrimination, from the present back to the act of discrimination. That's called back pay. And again, I'm a great one with these lines, but what I tell employees is, here's where you were. This is what you were earning, and this is what you're earning now. Now, maybe you don't have any job, so the gap is 100%. Or maybe you got a job that pays half as much or 2/3 as much. Okay, there's still a gap. So until these lines cross, until you're making what you were making, then there's still a gap and there's still damages that are accruing. And when you look at those damages from the present back to the time of the termination or failure to promote, etc., that's called back pay. But if you can establish that your lines aren't going to cross until sometime in the future, that's called front pay. And you're entitled to ask a judge and jury to award back pay and front pay, as well as additional damages to compensate you. I mean, problems in the employment sector, in the employment relationship, job problems, psychologists rank them up there right along with divorces and right along there with serious problems with relatives and right along there with health problems, major health problems. It's a traumatic time.
Because some people go postal, as that saying goes. Right?
Well,
people get very angry about
that is something. The emotions are extremely high on both sides, because employers they want to say, you know, we didn't do it, and it really irritates us that somebody says we did. And employees say, you know, look, I was doing a fine job and I got screwed, and I'm really mad. It embarrassed me and it hurt my family. So you're entitled to ask for damages from the jury to compensate you for the hurt that was caused.
Well, that's sort of difficult to prove, though, isn't it? I mean,
Sure.
that's just the plaintiff basically just have to sort of show the jury through the